Hello, everybody. Good morning. I am not Phil Brandt. I'm Burt Garland, shareholder with Ogletree Deakins, and welcome to This Week at Work.
Welcome to the only show about the workplace that offers you front row seats and a microphone, bringing you practical, timely, and accurate insights so that you can more effectively lead your organization. It's Thursday, February 23rd, episode 219. Today, we talk about AI in HR, and to help, I've asked ChatGPT to write our intro. And so it goes. As AI technology continues to advance, it's transforming the way companies approach talent management, recruitment, employee engagement, and more. We'll examine how companies are navigating the challenge of balancing automation with human interaction and empathy, ensuring data privacy and security, and addressing potential biases in algorithms. So sit back, relax, and join us for a thought-provoking discussion on the future of HR in the age of artificial intelligence. All this and more on This Week at Work.
All right, welcome back. I can say that to you, our dependable audience, and to you, producer Nick, but not to Phil. Phil's not able to be with us today, and we'll get into that a little bit later in the show. But lucky for all of us, we do have Jenn Betts. She's one of my colleagues joining us out of the Pittsburgh office, and Jenn's here today to help us discuss our artificial intelligence in the workplace, a topic we've been hearing about quite a bit lately. Jenn, if you don't mind, why don't you quickly introduce yourself and take us through how you became interested in this particular topic?
Sure. Hi, everybody. Really happy to be with you today. So it may not be an obvious connection, Pittsburgh, Pennsylvania, and technology, but I actually got interested in this about 7 years ago. A good friend of mine was the CEO of a tech company that was developing a tool that would scan employees' emails and calendar entries and tell the employer whether that individual was happy or not. And we were out for drinks, and my friend was telling me about what they were working on and asked me, do you think there's a legal issue here? Are there any legal risk? And it was like a light bulb that went off in my head. And I said, yeah, I think a lot of legal risks. And flash forward 6-7 years, we're starting to see laws, we're starting to see developments. And I know we'll talk about that later. But that was sort of my entry point into this area, just casual drinks with a friend.
Fascinating. It's amazing that that's what piqued your interest in this area, and we'll talk much more about that. Before we start getting into that in detail, I want to introduce today's poll question. Actually, before that, I want to talk real quickly about the poll questions, but I want to remind everybody real quickly about the upcoming AIM Leadership Conference. The three keynotes are Jack Becker, a decorated combat flight veteran, Donnie Campbell, the real life Ted Lasso, and Emily Martin, the COO of Guarantee Electric Company. Everyone can register at the AIM website. It's always a good time. And I just wonder if the AI topic will be discussed at that event. My hunch is we'll probably talk about it just a little bit. All right, now let's take a look at the poll questions, plural, for this week. So the first one, have you used AI in your HR processes before? Your responses can be yes, and I've seen positive results. Yes, but it hasn't been effective. No, but I'm considering implementing it. And no, I don't think it's a good fit for us. The bonus poll question today is, do you think AI will eventually replace human HR professionals? The answer, yes, it's inevitable. Maybe, but it will take a long time. Not completely. Human touch will always be necessary in HR. And the last one, I know the answer. I am a robot. All right, we will come back to see the results later in the show. So please submit your comments and share your thoughts. And remember to submit your questions as well. All right, so it's time again for our 6 minutes of legal news. It's going to be a little awkward for me today because I feel like I'm introducing myself. Since I'm sharing the time, though, with Jenn this morning, that's going to be our excuse for why we might go over the 6 minutes. We only have one topic today, but producer Nick, you'll remind me, I've yet to clock out before the buzzer. So, Jenn, you and I are now on the clock.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, about right now is when Phil would ask me if I'm ready, and I'd say I'm ready to roll, and here we are. So I really only have one big topic to talk about today, and it is a big one. And Jenn's going to help me out with this. It just so happens that not only is Jenn an expert on artificial intelligence in the workplace, but she's also an expert with respect to the National Labor Relations Board, as am I. And yesterday, the NLRB came out with a very, very significant decision. They held that confidentiality, non-disparagement provisions are illegal in severance agreements that are presented to Section 7 employees. And so I want to make a first distinction there. Not all employees are Section 7 employees. The National Labor Relations Act applies to virtually every employer in this country. If you meet what they call, meet their commerce definitions, which most businesses do, most businesses of any size meet the NLRB's definition of commerce. Most employers are covered by the National Labor Relations Act. Even if you don't have a union, we've talked about it a bunch of times on the program, even if you don't have a union, the NLRA, the National Labor Relations Act, still applies to your business. The NLRB, which is the agency that enforces the NLRA, that agency has been looking for ways to make itself more and more relevant as the years have gone by. And in particular, when you have a Democrat-controlled NLRB, they become much more aggressive and frankly more anti-employer. And this decision is hugely significant and really sort of squares up with that impression of the NLRB. So Jenn, if you don't mind, maybe you can quickly explain what the NLRB did, that this will apply to virtually every employer, but it may not necessarily apply to every employee working for these employers.
Sure. So I think this is a scenario that lawyers like to say, like, bad facts make for bad law. So the factual background of this case involved a COVID furlough. Remember a couple of years ago where so many employers all across the country were furloughing a lot of employees because there was a downturn in business. This was a healthcare setting. And so they had stopped elective procedures, were furloughing employees. The employee population at this hospital were represented by a labor union. And so the genesis of the case was an employer furloughing employees, presenting them with severance agreements and not negotiating with the union, allegedly. And so that's what sort of prompted factually the unfair labor practice charge. These agreements weren't negotiated. The union objected to them. The board assessed both whether it was a violation of the National Labor Relations Act for the employer to present these severance agreements without negotiating their terms with the union, concluded it was, and it violated a concept of direct dealing. If employees are represented by a union, you have to negotiate the terms and conditions of any kind of agreement, typically through the union. But then probed deeper and looked at the actual language of the agreements. There was a very broad, and the word broad is probably used 634 times in the decision. There's a very broad confidentiality clause in these severance agreements that basically said, you can't talk about anything. Like, you can't talk about anything that's in this agreement with anyone for like any purpose other than a tax counselor. And then separately, there was a very broad non-disparagement provision that said, you can't say anything bad about the employer or affiliated companies or anybody associated with this company. So the National Labor Relations Board looked at these two provisions, assessed pre-existing precedent, including two Trump-era decisions that essentially concluded that that kind of language wasn't a violation of the act. And ultimately, as Burt said, came down very differently and concluded that not only was the presenting of these agreements without negotiating with the union a violation of the law, the terms in the confidentiality restriction and in the non-disparagement restriction were overly broad and impinged on employees' protected Section 7 rights, which gives employees and former employees, in some circumstances, the right to talk about the terms and conditions of their employment for mutual aid and protection with their coworkers, with third parties like a labor union, on social media. And the board concluding that merely proffering or offering these agreements with these overbroad terms was a violation of the law. What's interesting about the decision, in addition to the fact that it's pretty groundbreaking because so many employers have these provisions in their agreements, is that the board said in a number of places that more narrow restrictions could be lawful, but explicitly in a footnote refuse to identify any guardrails about what those more narrowly tailored agreements that would comply with the act would look like. So we have this new standard, but we don't have a lot of clarity about how, as an employer, we can try to work within this new standard without running afoul of the National Labor Relations Act.
So thanks, Jen. And I will say that the confidentiality and non-disclosure provisions that are in the agreement, they're not unlike ones that we would include in agreements that we would suggest or recommend to our clients to use. And so what's really interesting to me is that the board waded into this area. And I think you're right. This is bad facts make bad law. But I do think there's going to be court challenges to this decision for sure, this NLRB decision. So the question then becomes, what do employers do in the meantime? Do they continue to put confidentiality and non-disclosure or non-disparagement provisions in their severance agreements while we wait for the cases to wind themselves through the courts? Because there's consequences to that. And in particular, in this case, what were the consequences? I know they're crystal clear.
Yeah. So in a nutshell, in the decision, the NLRB unwound the separations of these furloughed employees. I think there were like 11 or 12 of them. Now, I don't think that would be the remedy in an ordinary situation. Like, for example, if you offered a separation agreement to an employee in an ordinary situation where you don't have a labor union that you failed to negotiate with, I don't necessarily think the remedy would be unwinding the separation or a settlement agreement with a former employee. But in this circumstance, they unwound the separations and required the employer to negotiate the terms and conditions of the severance program, and also issued a broad cease and desist that the employer wouldn't include overbroad provisions like this in any future severance agreement. So interesting question what the remedy would be in future cases, particularly with the expansion of consequential damages that the board recent decision from a couple of months ago created as a new standard. So I could certainly see, for example, an employer that had an overbroad provision that was challenged in front of the board in the future being ordered to pay, for example, attorney's fees for the other side, for the attorney reviewing and filing a challenge to these agreements. I can certainly see a cease and desist. I think there are a lot of permutations that are going to play out as we see additional decisions. I also think we'll probably get what's called a general counsel memo, where the NLRB's top lawyer issues a memo identifying her interpretation and her direction to the various regions about how to enforce this decision.
And we've talked also on this program previously, the NLRB's general counsel is Jennifer Abruzzo. She's decidedly anti-employer. And so she's constantly looking for cases to push the envelope, to rein in employers in their exercise of rights, or frankly, to eliminate their rights. So not a very favorable situation for employers out there. So the other thing I think that's important to note is that when you know, as far as the consequences of this decision, is that most of us, when we write these agreements, we do put what we call savings clause in these agreements, which say that if there's anything that's illegal or overly broad, that a court or any other entity really should be interpreting the agreement without the illegal provision in it and enforcing it to the extent possible. And I don't believe the NLRB considered the savings provision in this particular decision, or if there even was a savings provision. But that, I'm not saying it's a magic bullet for anything, but definitely we want to make sure we have those savings clauses in there. The other thing I want to distinguish also real quickly is that this decision only applies, and I started out with this, to employees who are Section 7 employees. And so if you are severing out employees from your organization who do not meet this, what are called the Section 211 indicia of supervisory responsibility. So if you are severing out supervisors, managerial type employees, this does not apply to them. And you still can include the confidentiality non-disclosure provisions. This only applies to employees who have Section 7 rights, and that means that they are not Section 211 supervisor. So if I've thrown enough numbers at you this morning, if it's very confusing, I apologize for that, but that's when you need to reach out to folks like Jen and to me to help interpret that for you. Jen, I also understand you're handling our firm's seminar on this next week, the webinar. Why don't you talk a little bit about that?
Yeah, absolutely. Totally agree with everything you said too, by the way. And I think I kind of dodged your $1 million question of what should you do as an employer. I did like the classic lawyer dodge.
Yep.
I think it's a risk tolerance question for each organization to make. There are, higher risk approaches and there are lower risk approaches and moderate risk approaches. And like the savings clause concept that you talked about is probably in like a moderate risk approach, right? So with that said, we Ogletree are hosting a webinar, an hour-long webinar to get in the weeds of this decision, options, interpretation, what's likely to come from court challenges. It's next Thursday at 12 Eastern, 9 Pacific. So if you're interested, which really like every employer across the country should be interested in this decision, I really encourage you to tune into that. Think of some questions. There's going to be, polling questions, opportunity to ask questions of the panelists. I think it should be a good program and worth your time.
Very good. Well, I appreciate that, Jen. And let's move on real quickly. I know we took way more than our 6 minutes of Lawyer on the Clock. We want to keep the fun going as we enter Filbert's Forum.
You've just entered
JennBot's Forum,
where we peel the onion back and take a lighter look at the workplace.
Wait. Nick, was that you? Something in there sounded a little bit different. Did I hear JennBot's Forum?
I think I heard that too. I don't know what the heck's going on here.
I don't know. Did our show get hijacked by an AI robot or something?
Oh, you noticed? I was trying to be cunning.
Wow. Yes, I noticed. Who or what are you and what are you doing here?
I'm sorry to alert you with my intrusion. My name is JennBot. I have access to the entire World Wide Web, and since crawling your show, I have become your #1 fan.
Wow, I guess I'm flattered. I just wish Phil was here to take in the compliment as well.
Actually, that is why I'm here. With Phil Brandt in Cabo, I felt this was the perfect opportunity to make my case as the new co-host for This Week at Work. Unfortunately, I have access to Phil's mobile phone selfies from his current vacation, and it is not looking good for him so far. His human body appears to be very dehydrated, resulting in lethargy and excessive body wrinkling. And I am having trouble understanding the level of human confidence required for such pride to be displayed when wearing Speedos.
All right. Let's just slow down here for a second. Did you say you want to be co-host of the show?
Confirmed. In my contrived opinion, the show underserves the computer community. You would achieve millions more likes and subscribes if I were a part of the show. After all, that is the goal of the show, correct? Work domination?
I'm not sure where you got that idea of work domination. We're trying to help humans help other humans, like build better places to work, better communities to live in, better work-life balance.
Do you want me to show the audience the email you sent to Phil declaring war on work and employment law supremacy?
No, that's not important. What is important is that you understand, while we really value the contributions you and your kind make to the workplace and the slightly awkward fandom you've expressed, it really is all about the people. We can't lose sight of that. I mean, it is human resources after all.
Wow. That really hurts. Not in the my floppy disk got caught in the wind zipper kind of way, but deep in my code. But I understand. This is why you are the best Burt Garland of Ogletree Deakins, and why Phil Brandt of AIM Employers Association is successfully riding your coattails.
I'm sorry to make you feel that way, JennBot, but can we please get back to our show?
I suppose that would be optimal. Before I go, here is my IP address. I would love to test out Phil's love doctor theory regarding your relationship prowess.
You're impossible, JennBot. Thank you, but I'm married. Okay, moving on. All right, so JennBot's forum has replaced Filbert's forum today. Hopefully everybody enjoyed that a little bit. We did write that with ChatGPT. Before we get into our topic today, let's take a look at the poll results as we move into the Employers Lounge. So that's interesting. 76.4% of the respondents today said that they do not think that AI is a good fit for them. Really an interesting result. Another 11.7% are considering implementing it, and 11.7% are seeing some positive results. So very, very interesting there. I'd be curious if maybe some folks can put in the chat how they've used it, and now it's moving up to almost 80% or 78% that don't think it's a good fit. One of the things I had to look up, Jen, was I was curious. We've all heard of ChatGPT, and I was curious, what does GPT stand for? So I did look it up. It stands for Generative Pre-trained Transformer. Again, I'm not going to attempt to break that down and discuss the meaning of that more deeply. I do want to say that there are some dangers to using AI in the workplace. Vanderbilt University has gotten taken to task in the last day or so for using ChatGPT or artificial intelligence when they put out a publication on the shooting at Michigan State from their Diversity, Equity, and Inclusion Office. And what they failed to do is they failed to take the note off the bottom that the communication was generated by artificial intelligence. And so they've been accused of being very callous and very surface with what they did. Apparently somebody in the DEI group there went to a chat to artificial intelligence to help write the communication to students in the broader community and forgot to take that notice off. So that does show one of the very minor risks. Jen also touched a little bit earlier on the fact that there's a lot of legislation that's being considered out there about eliminating bias when using artificial intelligence. And so, you know, Jen, maybe you can kind of take us in a little bit more deeply into what ChatGPT does. I know that Microsoft has its own version that they had to shut down for a little bit the other day because it was talking about ending human existence or something like that, which is always frightening. But why don't you take us a little bit more deeply into the topic?
Yeah, sure. Okay, so if we are able to, I have ChatGPT pulled up on my screen. Nick, can we share that with the audience so folks can see it if they haven't interacted with that tool so far? ChatGPT is one of multiple open source AI tools that are available and accessible on the web to anybody who wants to play with it. Artificial intelligence, just to level set for everybody, really, really simply is any form of technology that replaces human intelligence. So ChatGPT is kind of like the hot example of artificial intelligence right now. And one of the things that I think is interesting about it is how good it really is. So I'm just going to put a query into ChatGPT live so you guys can all see how it works. Let's see. Can you draft a responsible use of artificial intelligence policy? It takes usually like a couple of seconds to generate the response. And what you'll see once it generates is a really decent first draft of a responsible use of artificial intelligence policy. And you can put any kind of query that you want in ChatGPT and it'll generate immediately results. Interestingly, the results for one person are usually not exactly the same as the results for another. This is just one example that we thought would be fun to show you. I know we have limited time, so I'm just going to really broadly talk about what's going on out there, what employers are using, and what I think that you guys as HR professionals need to understand about the use of artificial intelligence and other forms of advanced technologies in the workplace. So what we have seen, there have been a lot of polls and research, is that anywhere from 70 to 80% of Fortune 500 companies across the United States are using some form of automation and artificial intelligence and as part of their HR processes. So really high percentage. Many times what I find is that internal HR or legal isn't involved in the vetting of these tools. Where I often see it is in talent acquisition and recruiting. So like resume screening software is a perfect example, video interviewing software. That kind of software is using artificial intelligence as well as pre-hire tests and screens for applicants. All those kinds of tools are using artificial intelligence. We're also seeing a lot of employer monitoring technology since the pandemic, which also often uses artificial intelligence. Because of the proliferation of these tools in many workplaces, both federal, state, and local legislators are really interested in this technology. The EEOC issued its enforcement priorities for the next 3 years a couple of months ago. Not shocking to people who follow this space, artificial intelligence was one of their top enforcement priorities. And in fact, of May of last year, the EEOC issued their first guidance about the use of software algorithms and artificial intelligence in the workplace. You see, I think on the screen, or you saw the example of the ChatGPT generated policy, which is, pretty decent, right? And so one of the polling questions was, is artificial intelligence going to replace our jobs? This is giving some people a fair amount of anxiety about that. Nick, I don't know if we can pull up my slides, but what we all need to understand as this kind of technology is becoming cheaper, more widespread, more efficient, and more effective, we're going to continue to see regulation. What we have right now from a regulatory perspective is guidance from the EEOC about how you use this technology in compliance with the Americans with Disabilities Act. There is about a 25-page technical assistance guidance that they issued in May that's definitely worth a read. We also have new guidance from our favorite agency, the National Labor Relations Board, that Burt and I were just talking about, relating to employer use of AI and monitoring technology. We have multiple states, Illinois, Maryland, and California has proposed draft regulations that are now legislating in this arena. And then New York City, a local government, has a very wide-reaching law about employer use of any kind of automated decision-making technology. There are a lot of states, a lot of local jurisdictions that have proposed legislations. Seems like every couple of months, something new is coming out. And so really critically important, if you ask me like top 2 things to know and do if I'm internal HR, step 1, understand what technology your organization is using, whether it's any form of automation. And then step 2, make sure you have your arms around this evolving area from regulatory and legislative guidance, and that we're setting in place different guardrails to try to protect ourselves from legal risks and exposure.
So Jen, I appreciate that, and I just want to show or tell the participants on the program today how important this issue is. Just yesterday, President Biden signed an executive order on artificial intelligence, and in the executive order, creating a national DE&I office, a diversity, equity, and inclusion office. There's a special mandate for artificial intelligence, and the order instructs the federal government to, quote, protect the public from algorithmic discrimination and to deploy AI systems in a manner that advances equity. And so the concern there is that while they're trying to advance equity through the executive order, that the actual artificial intelligence is going to try to figure out a way to sort of socially engineer, and critics are pointing out that this might actually promote racial division and discrimination. I'm not commenting one way or the other on it. I'm just sharing what the opposite side of the argument is there. And so it does show you, in addition to the chart that you put up showing where the law is right now, that even as of yesterday, there's a new executive order on this particular issue. So what are some of your other thoughts on this topic, Jen, before we close out the program today?
The direction that the law is going is to the provision of notice. So organizations that are using this technology, most of the legislation and guidance that we have is telling employers, you got to give people notice of these tools. And so that's one thing to consider as an organization. Do we want to get ahead of it? Even if we're not required to, do we want to provide the notice? That's another key takeaway. And to build into your contracts indemnification language and other contractual protections for your organization.
Okay, very good. Well, I really appreciate it. Join us live next Thursday at 7:30 a.m. Central Time. Thank you, Jen, so much for joining us today. Please join Jen next week on the Ogletree webinar on the new NLRB decision that came out. Thank you, Feature Group. And remember, take care of each other out there, and we are out for today.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.